Welcome to Got Invention Radio. I'm your host, Brian Freed, and tonight we have a guest. His name is Kevin Prince, and he's a registered U.S. patent agent. He's also an inventor, and he's the author of a book called The Art of the Patent, which features some of the best patent artwork in the last 200 years of the U.S. patent history. Welcome to the show, Kevin.
Thank you, Brian. Thanks for having me on again.
So I gave the listeners a little bit of information about you, but I know that there's a lot more. Help us out and tell us a little bit more about yourself there, Kevin.
Well, as you said, I'm an inventor. That's how I got into this business. And one of my first inventions was a brainwave reading alarm clock, so you could wake up at the peak of your sleep cycle as opposed to when you're in a deep delta sleep. And I thought that was a pretty good idea, especially because I'd slept through several alarm clocks. And so I did a patent search on it, or I had a patent search done on it, and it turns out that that invention had been done 10 years before. It was patented, and it was exactly the same as what I was thinking. So, that kind of got me started on how patent searches are done, how patents read, what goes into a patent, the level of detail that you need. And it really showed me that I had a good idea. It's just that I wasn't fast enough. And now, in fact, they have that product out on the market. Although I think it uses a different method than I was thinking. Mine would have had to include electrodes while you're sleeping on your head. So it wasn't really practical at the time. That was like 20 years ago. Oh. But it was kind of an interesting thing to see your idea in a published patent, and it really gives you a good idea of what it takes to get a patent.
Absolutely.
So that's kind of how I got into it, and just started doing patent searches and writing patents for a patent agent. And he kind of taught me the ropes, and been having fun with intellectual property ever since.
Very good. Kevin, now, when I first introduced you, I mentioned to the listeners that you're a U.S. patent agent. If you don't mind just taking a moment and explaining to us what the difference is between an agent and an attorney.
Yeah, patent agents and patent attorneys have both passed the patent bar exam at the patent office, and we both have 4-year science or engineering degrees. I have a 4-year engineering degree out of Berkeley, and the only difference is I don't have a law degree. So I can do everything that a patent attorney can do at the patent office. I just can't go beyond that and help enforce your patent in court, or write cease and desist letters to your competitors, or do anything that would be considered the practice of law.
Okay. And because of that situation, I mean, you work with other attorneys also. So what happens is an agent, just because you're not practicing law, tends to be a little less expensive than the average attorney out there. Is that right?
Yeah, well, for one thing, my clients aren't paying for my law school, and I don't have a marble coffee table on the 16th floor of a building somewhere. So I think patent agents tend to work a bit less expensively than attorneys. They don't have quite the overhead.
Okay, understood. So you're focused on design patents. Now, there's many different patents. If you don't mind, if you can take a moment and explain to us the type of patents out there, and then we're going to spend the rest of the time on the show focusing specifically on design patents.
Sure. There's two basic types of patents. There's the utility patent, which protects how something works, and a design patent, which protects how something looks. And the example that I give is sunglasses. If you have a new kind of pair of sunglasses with a unique style, for example, and you want to protect the way that looks, you would use a design patent. But if you came up with the idea of the polarized lens, that's something that works differently, and you wouldn't really care what the sunglasses look like. You'd want to be able to protect that the sunglasses work in that way to filter out polarized light. And so that would take a utility patent. And by the way, they're not mutually exclusive. You can get both types of patents on the same product.
But when you're saying that it protects the design, when you look at utility patents or the functionality patent, right, it also has pictures in there. It has diagrams of the the concept itself as well. So does that also cover the design patent?
No, because it doesn't matter really what the product looks like in a utility patent. And that's why utility patent drawings can actually just be hand sketches, and I've seen some really very simple utility patent drawings that just show the concept. They just show that there's a particular feature or set of features, and it doesn't have to look like the finished product. Now, it's nice when it does, because then it's very clearly a patent on your product, and a lot of times people want the utility patent drawings to match what their product looks like. But as long as the drawings show the functionality, it really doesn't have to look like your finished product. And that's why it's considered to be, utility patents are considered to be broader than design patents in general, because, again, it doesn't matter what it looks like. It just matters that those particular functional features are included.
Okay, understood. So for the listeners out there, the utility patent, otherwise known as the non-provisional patent, is for the functionality of your concept for your invention, and a design patent is ornamental. It's the look of it. Is that right, Kevin?
Yeah, let me just correct one little thing that you said.
Sure.
A non-provisional patent is either a utility patent or a design patent. It's a patent that's going to get examined at the patent office.
Okay.
So a non-provisional utility patent is a utility patent, and a non-provisional design patent is a design patent. A provisional patent is only a utility patent. So utility patents break down into provisional and non-provisional, and there's no such thing as a provisional design patent. So when you say non-provisional, most people understand that to be a utility patent, but technically speaking, it's actually either a utility patent or a design patent.
Okay, very good. Thank you for that. And if you could just give us a quick definition of what a provisional patent is.
Sure. A provisional patent, I like to consider it a placeholder for a utility patent. It allows you to say patent pending for 1 year, and it's kind of like calling ahead at a restaurant to get your name on the list. But you got to show up at the restaurant if you're going to get the table, right? So it's kind of like a reservation for a non-provisional application, and it basically gives you a year to make sure that your design is finalized. Provisional patents cost less typically to prepare, and they can be prepared more quickly. And so I've had clients who've done multiple provisional patents on the same product, and then when they're finally finished designing, all the bells and whistles, and they have a finalized design, that's when they file the non-provisional, as long as it's done within a year of the first filing of the provisional.
Okay, got it. Now, before we call up a patent attorney or patent agent, what should we do first? I mean, I'm big on telling inventors out there to do a patent search, whether it's to start off doing your own, going on the uspto.gov website, going on Google Patents, going on the internet and putting in multiple descriptions of your idea to be able to see if it's something that already exists out there. And the one point is, when you're going on the United States Patent and Trademark Office or you're going to Google Patents, when you're looking at the patents, there's two different ways to look at what they are. And if you can help us to identify that would be great for the listeners.
I prefer Google Patents over the PTO website just because it's a lot easier to use. And there's actually three different things that professional researchers look at. The first thing is pretty easy for people to do themselves, and that is a keyword search. So you go on to google.com/patents, and you type in some keywords that describe your product. One thing that's helpful is to try to come up with a single noun that describes your product. What is the one word? If you could only use one word, what is it? And then look for synonyms for that word. And that will be one set of keywords that you're using. And then you can use other sets of keywords that describe different attributes of the product. So, for example, let's say, I have the patent that I got for myself personally, most recently, is a reusable coffee cup sleeve. I'm trying to get it licensed at Starbucks. And so for that, I would use sleeve as the noun. And then obviously it has to do with coffee or coffee cups. And so I would use some synonyms for that. Anyway, try different permutations of these words, and you'll get different search results every time. But pretty soon you'll start to see some of the same ones showing up. And after a while, you'll get the feeling that, there's really not much else that you could put in there to get a patent that you haven't seen yet. And that's when you start to get to the point where you're getting more comfortable that you've seen everything that you need to. That's how you do a keyword search. And in fact, I have a worksheet on my website that you can download. It's a PDF worksheet that walks you through how to pick these words and how to use the OR command to put them together in a search strategy.
Great.
And that's free. You can just download that. That's under the New to Inventing link on the website.
And what's your website, Kevin?
It's quickpatents.com. QUICKPATENTS.com.
Okay, great. Now I mentioned
so keywords is one of them,
mm-hmm.
and then you also have to search on. Ultimately, you have to search on class and subclass, and then also forward and backward references. And I don't know if you want to get into that on this show, but those are the three ways that are available to the public to search. Obviously, patent examiners have some additional tools. But certainly start with the keywords, because that's the fastest way to get some relevant patents.
Okay. So then when we find something that's similar and we start to take a look at the drawings and claims, to start off with, there's two differences with the way they're issued patents. There's a D in front of some of them, and some don't have a D. Can you explain that?
Yeah, D stands for design. So any patent that you see that starts with D or DES is a design patent. And another clue that you're looking at a design patent is that the patent is basically just the illustrations. There's very little text in a design patent. There's no mention typically of materials used, different configurations, how these things are put together or manufactured. All of that is what you would put in a utility patent. But a design patent just has the illustrations, and the illustrations are, you'll typically see they're quite detailed. Every surface has some contour shading on it, so you can tell what the shape of that surface is. And there are no numerical callouts pointing to different things like, this is a slot, this is a tab, this is a wheel. The numerical callouts that you see in most patent drawings, those are all going to be utility patents, not design patents. Design patents is really just showing the different views of the product with nothing extraneous in the illustration.
Okay, understood. So now, if there's a product, or let's say there's a design patent that got issued, and I come up with something that's similar to it, but not exactly the same, how much of a difference does there need to be before I'm able to get a design patent or get rejected?
Well, that's a good question. I get asked that every day, and unfortunately, there's no clear answer. It's a gray area, and the law that is used for that is what's called the ordinary observer test. And so, basically, if you see a design patent that looks similar to what you're making, you have to ask the question: would an ordinary consumer who saw both of these items on the shelf, would he get confused between the two? And perhaps the best way to kind of illustrate this is with an example. I think most people are familiar with Crocs shoes, the sandals that all the kids are wearing.
Oh, yeah.
They just won a couple of design patent cases against a Chinese importer that was bringing in similar-looking sandals, that the holes in the sandal were a different shape, and the pattern that they formed on the front of the sandal or the top of the sandal was a different pattern, and even the strap going around the back of the ankle was different.